unfortunately, we don't have any representatives here attempting to defend what's currently happening. Why might that be? I don't know. You know, I found sort of throughout this process that you know, we keep being told how good you know, this trade deal is, and the ICS mechanism as part of it, and yet nobody seems to be able to you know, stand up in a public setting and actually discuss the merits or demerits of it. So I suppose with regards to what I'll talk about, I'll talk a little bit about further kind of myths that are there around CETA and what's happening at the moment. There was a particularly memorable article in the Irish Examiner on February 5th, which was CETA, a bitter pill for Greens to swallow. So I suppose on that, as that's one of the only articles out there actually defending CETA and the ICS mechanism, I'll sort of you know, take some of the lines of thought from that maybe and go through them. So with regards to this particular situation, there's been a lot of focus on the Green Party and their positioning on this issue, which as a former Green Party member myself, I understand because it's quite the 180 that's happened here. But I suppose at the end of the day, CETA is an all of government decision. And I suppose looking at the real politic at play here, the attitude of you know, most of the Green Party, with some honourable exceptions, is that to reach the conclusion basically that the view of the Green Party on any matter in government is basically irrelevant. So I suppose it is worth, however, responding to the arguments that were presented in that article, because I suppose any of us who have been doing a bit of campaigning on CETA, we're starting to see these lines sort of coming back to us as well. And I suppose a lot of these do need to have a bit of myth busting done on them. So I suppose at this moment in time, it would appear that CETA is being discussed in the EU Affairs Oireachtas Committee, and also, as far as I know, is still on the work plan of the Climate Action Committee. But I think it's one of these kind of like going by what Senator Higgins has sort of outlined as well, in terms of, you know, the sort of seismic sort of demerits of this irrevocable 20-year agreement that government parties are signing every single person in the Irish state up to. I mean, it would seem fairly clear to me that it would need to go to as many Oireachtas committees as possible, and specifically, I would say, and most importantly, the Justice Committee would be one of those. I mean, this is essentially a parallel legal system that's being introduced, as Senator Higgins has outlined. So with regards to, you know, CETA, it's the Comprehensive Economic Trade Agreement. It's mainly a trade agreement between the European Union and Canada, but it also includes elements like the investor court system, and that's the mechanism that allows companies to sue states over interventions that interfere with future profit. So the substantive nature of this agreement was to reduce tariffs on trade between Canada and the European Union, and tariffs are a tax on trade. So however, like the tariff regime, and therefore the trading part of the agreement, has actually been in place since 2017. So a lot of public representatives are coming back and they're emphasizing tariffs, but that's actually not what is currently at stake here. It's actually, this is to do with the investor court system, and any kind of confusion that's out there. I suppose perhaps a lot of it is being put out on purpose at the moment, just to kind of, you know, deflect from what's actually happening here. So one of the first points that was posited in Senator O'Reilly's article is that the ICS is a very substantially updated version of the ISDS. And there have been a number of developments in how the deal would operate, including an opinion from the European Court of Justice, and then links that ECJ opinion with work that the Green Party MEPs have been doing in Europe, moving the ISDS towards the ICS structure. Furthermore, we're advised in that article that sectors such as environmental protections, labour rights, and other aspects of our shared lives, which can be taken to include housing, I suppose, are now explicitly excluded from the deal as it stands. So that's not true. Like, that's not true at all. So while we can say, like, the Green Party in Europe played a role in moving the ISDS towards the ICS structure. I think that we're not really there at all just yet. And I suppose, you know, members of the European Greens have actually been saying to Green Party members, you know, that they shouldn't be trying to put a lipstick on a pig. I don't really know if you can get more blunt than that in terms of describing what the ICS is. There isn't, like, those changes that have been outlined I'd want to have a lot more discussion at an Oireachtas level about what those are. One other thing as well, just to sort of point out, or in the interest of fairness, is that the Senator, in referring to the ECJ opinion, might recall that Sinn Féin's Matt Carty co-signed the motion of resolution to refer the trade agreement to the ECJ. So, you know, because there was, I believe that article was actually in response to something that Sinn Féin TD Mairead Farrell had written. So things are getting a bit hot and heavy in the article. But Sinn Féin has actually played a role at the European level as well in sort of being opposed to this in a similar way to the Green Party. So I mean, I don't really think this is necessarily a party political issue. So something that's also possible now is to include certain sectors from the ICS. So that part is true, but this facility is made available through what is called a BIT, or a bilateral investment treaty. So this facility wasn't used by the Irish state in a very meaningful way. So that's something that's not to be relied on to argue in favour of agreeing to the ICS. So even if we were to accept that the ICS is a substantively different thing from the original ISDS, the Irish state in particular has its own specific context here, which is that, you know, being good little boys and girls, we didn't actually put too many exemptions in there, or we didn't exclude many sectors from it. So I don't necessarily think that, you know, we're quite at the same context as maybe other European countries either, in terms of not using that facility. So the last kind of argument that's presented in the article is that the ICS does not interfere with governments setting their own policies and legislation. And, you know, this is the red herring that Senator Higgins has talked about, but it's a particularly prominent red herring, and it's one that has come up a lot. You know, and I suppose in terms of like the letter of the law, you know, there's never actually been a question of legislation or policy being directly overturned. Like, the problem here is that it lies basically in allowing companies, albeit these are companies requiring substantial business activities in the relevant country, to sue states over the loss of future profits as a result of state intervention. It's also worth noting as well that the criteria for what constitutes substantial business is as yet untested in case law in European context. So the reality is that cases may be taken against the state for damages that have run into billions wherever these systems existed before. And it's also quite interesting that you know, Canada as a trading partner in this agreement has actually extricated itself from similar arrangements that it previously had as trading partners in agreements with the US and Mexico. So if it's not good enough for them, I don't really see how it's good enough for the Irish state. Like, that's just a basic kind of negotiating thing, that if your negotiating partner is not willing to do something themselves, you know, are you really going to agree to take that on and have them sort of inflict it on you? Because the reality of these types of systems, as well as that Canada is particularly litigious, and the types of companies that you know have been taking these cases are companies that tend to be involved in extractivist types of industries. So mining in particular is one example of that. So if these cases with such high financial liability can be taken on sectoral issues that the Irish state has not ruled out, like, it logically and evidently follows that such risk being introduced would make it very difficult to introduce new policy in future. And I suppose in economics, the term that we put on it is transaction costs. So the transaction cost is the cost of doing something. And I think this is kind of the thing that's actually at play here, because basically the transaction costs of doing so, or introducing a new environmental policy, for example, while the ICS exists, could possibly run into the equivalent of the annual spends of bigger government departments. That's billions of euro. And for a real world example, that's happening currently right now, like, you only have to look at how the Irish state has always treated all potential litigants. So if you look at the survivors of institutional abuse, for example, the survivors of symphysiotomy, or the cervical check scandal, like, we just have to look at these to know the chill effect in the state for legislating for such matters is very real. And that's only the state's citizens. And it's something that Senator Higgins has kind of alluded to as well, that I have firsthand experience of seeing, is in terms of like the drafting of the climate bill. The original draft of the climate bill, which many NGOs and activists and Green Party members such as myself said, you know, like the original draft of that bill was very, very weak. And the reason why it was very weak is that it was taking away things like it was taking away mechanisms from you know, the likes of Climate Case Ireland to sue again if the state was not actually you know, reaching targets in terms of like addressing climate crisis. So like, if the state is that afraid of its own citizens, they can't really turn around and say that, like, in terms of a multi-billion-dollar corporation, that they wouldn't be even more, you know, scared crapless over that, basically. I suppose in an international context, yeah, there is a pattern of larger companies using sort of punishment cases. So Philip Morris, for example, lost their suit against plain packaging on tobacco products in Australia, but they used the case and its cost to bully Namibia and Togo, which were emerging markets, into really lax tobacco laws. So like, this effect is not to be dismissed at all. I think a lot of my previous colleagues have used the phrase "a bitter pill to swallow" as a thematic emphasis, you know, on why they're just going to accept CETA, and why they're to explain the government position on accepting the ICS. And I, just to stretch the metaphor a bit, like, and I think it is appropriate to offer another interpretation of this phrase to aid discussion. So over millennia, humans have developed an evolutionary response to bitter tastes. This response, just because I hate the phrase "bitter pill to swallow," right, I'm just gonna do a little switcheroo on it, right? So over millennia, humans developed an evolutionary response to bitter tastes, which is to like spit out bitter tasting food, or to treat foods like that with caution. So our taste buds evolved to act as a biological warning system, in part because plants that taste bitter are often lethally poisonous and dangerous or fatal to ingest. So if the investor court system tastes bitter, it may be because it's poisonous. Case closed.